Good afternoon, proud and dedicated members of the National Federation of the Blind. Thank you, President Riccobono and Dr. Maurer, for giving me the honor of speaking to this incredible audience. I feel passionate about the issue that I will be talking about and saddened and angry about what I have seen. I speak to you today from the perspective of an attorney and a parent. Let me start by saying that I am tired of hearing judges, caseworkers, psychologists, and lawyers ask me whether my client is capable of taking care of his child merely because he is blind. This question is loaded with societal biases and incorrect assumptions regarding the capabilities of blind people. Those asking this question generally hold a tremendous amount of power and are wreaking havoc on blind parents and their children. When this question is asked and discriminatory decisions are made, we have no choice but to push back on every front, including legal advocacy in the courtroom, legislative initiatives in our state capitals and in Congress, and continuous education with state government, executive branch, and the judicial leadership. It should not surprise you when I tell you there's a constitutional right for parents to be able to raise their own children. Although at times, of course, this fundamental liberty interest must be balanced against the health and safety of a child, a parent with a disability should never be deprived of her child because of her disability. Sadly, too many times this has been the outcome. Let me tell you about some of the people I have had a privilege of representing because of the advocacy efforts of the NFB. My client was a young single mom with 2 children. Life was difficult for my client, but not because she was blind. When she found herself struggling, she contacted her local Department of Social Services for assistance. She thought this was a good idea, and many people might have agreed with her at the time. Although that department initially provided her with the support she asked for, the caseworker assigned to her could not fathom how this blind mom could take care of her 2 young children by herself. The caseworker grilled my client with question after question about how she could be certain that her children would be safe in her care. These questions put my client totally on the defensive and ultimately resulted in her young children living in foster care for 2 very long and painful years. Those with the power could not conceive of how my client could take care of her children. Thanks to the NFB and the advocacy and education that we provided to caseworkers, lawyers, and to the judge, these 2 beautiful children are back with their mom now. But let me tell you, this was only after hundreds of hours of visits where a sighted supervisor was watching my client's every move and scoring her on her parenting abilities. Had I, as a young parent, had someone watching me every time I bathed my kids, prepared their meals, played with them, put them to sleep, and then scrutinized me on each of these tasks with a scorecard, and then expected me to perform with complete perfection, I could never have passed this impossible test. But this became the expectation and requirement for those who held the power. Although this mother is strong and her children are thriving now, The painful absence of her children for those 2 years will always be a cruel memory. President Riccobono told you about my client Pedro, who wanted his 3-year-old daughter to come and live with him after her mother could no longer take care of her. The president explained, and I want to give you a few more details, the Department of Social Services had to do a home study, which was part of the process. That was fine. And here's how the report that I was reading read. The caseworker described Pedro's excellent skills in terms of housekeeping and his superb independence as a professional. She highlighted his excellent blindness skills in terms of mobility and use of technology. As I read that report, I thought how refreshing that the biases that this one generally sees in these reports, they're not there, until I got to the last paragraph. The caseworker concludes her glowing report with something close to the following. Because this father is blind, the young daughter will not be able to articulate whether she's being abused. Placement denied. Pedro was furious and called the NFB. He spoke to Dr. Maurer, who then called me. It took us several months, but we were able to get that caseworker to come back to the home, and she issued a second report. The report was identical, line by line, glowing recommendation of this gentleman. However, when I got to the last paragraph, guess what? The worker deleted that ugly paragraph and put placement approved. So Pedro, I know you're somewhere in the New York delegation, and I'm so thrilled that your little girl is now living with you and you're here for your first convention. So I salute you, Mr. Pedro. And let me tell you about another client and the infuriating and discriminatory actions that are taking place as I stand here today. In a private custody battle, a judge for the past 14 months has only allowed my client, a blind dad, to be with his little children if there's a sighted person present. There is no factual basis for this requirement. It is based only on the judge's fear that somehow it would not be safe for the children to be alone with their dad. This requirement is insulting and demeaning, unnecessarily expensive, and serves to limit his time with his children. We are vigorously fighting this requirement, but the legal system moves slowly, and in these types of cases, very unfairly. And all of you, I'm sure, know about the Missouri family whose baby was taken from them at birth because people did not think this blind couple could parent their infant safely. And what led to this? A hospital employee who thought that the mom was having difficulty breastfeeding her newborn. Well, how could that be? I personally remember crying all night long in the hospital the first night I tried to breastfeed my first baby. No one called in protective services for this sighted mom. Instead, they sent in the nurses and all the helpers to get me under control and to teach me how to do this. Our friends in Missouri instead were told that they either needed 24/7 care at home or the child would have to go to foster care. That's what happened for some 57 days until the NFB's advocates got involved and convinced the authorities that this injustice had to stop. It is my goal. It is my goal to help change the culture so that when I walk into a meeting with government officials with a blind mom or into a courtroom with a blind dad, those in charge are not focused on the question of how is this possible, but rather the truth that blind parents can parent as well or better than anyone else. My clients My clients have reminded me that all parents rely on some support system to effectively provide for their children. If I ever thought that I had raised my boys without the support of an army of others, I'd be fooling myself. Part of the education that judges and caseworkers need is a reminder of this truth. An occupational therapist from a wonderful organization called Through the Looking Glass often reminds me that it is imperative that a parent's capabilities should be considered in the context of the supports he or she uses, and that there is absolutely nothing wrong if a parent chooses to have supports in place to do certain parenting tasks. All that should matter is the parent is able, with or without supports, to provide for their children. The problem is when others decide what one needs. It is appalling that someone else can decide when a blind parent needs sighted assistance. The NFB has put together some incredibly valuable documents and videos that I've been providing to courts, caseworkers, and forensic evaluators. The publication Parents Without Sight and President Riccobono's video about a day at the playground with his 2 little girls are impressive and incredibly helpful. But I ask you to create more. I need to be able to show how blind parents work with their children on homework, how blind parents measure out medicine when their children are sick, how you change diapers or travel on a city subway with your kids, and how you and your children do all the day-to-day fun things that you do every day. I need to know and show sighted people who are in positions of power how you drop your kids off at daycare and then what you do day to day in your own jobs. I know it may sound lousy or even insulting for me to ask you for this, but it is the best way to help educate those who are asking these questions. At this time, and if you do more of these creations, you can control what people think about your capabilities. There are a number of reasons why these cases are so difficult and why we must fight the current situation on several fronts. A large majority of states expressly permit disability to be considered when determining whether parental rights should be terminated. Unfortunately, in many cases, the focus of these statutes is on the disability rather than the behavior or actions of the parent. It is up to the advocates to ensure that those proposing termination have the burden of proof that there is actual harm or substantial risk of harm to the health and safety of a child because of the parent's actions before any termination ever occurs. It is also critical to make sure that any determination take into account a person's abilities with the adaptive services and support services he or she uses. In child custody disputes, courts must make decisions based on the best interests of the child. However, many state laws permit the mental and physical health of a parent to be used as a proper factor to be considered when determining custody. What these statutes don't say is there has to be a showing of harm to the child before custody is denied. And when it comes to the state agencies who have the responsibility of ensuring that every effort is made to maintain children with their parents, we must push hard to make sure that a parent's disability does not diminish the services the state agency is providing. The Department of Justice recently issued a findings letter against the Massachusetts Department of Social Services, where it found that that department violated the ADA because it failed to provide assistance to a parent with a disability to help her keep her child, something that the agency readily does for parents without a disability. Contrary to the recent DOJ letter, however, courts have routinely held that termination proceedings are not governed by the ADA, and similarly, nor are private custody disputes. Notwithstanding these court decisions, I believe that the ADA can be a valuable lever with which to push state agencies and perhaps even judges to support rather than hinder the rights of parents with disabilities. The American Psychological Association seems to understand the biases that are contributing to the injustices that we are seeing. This national organization has issued guidelines that call for psychologists to remain aware of their own and others' biases when completing evaluations. The guidelines remind evaluators to recognize that people with disabilities have a right to a family, and that many adults with various disabilities can and do effectively parent their children. The guidelines also recognize that a functional evaluation is critical because it ensures that the decision makers understand how the parents parent. Just last week, I sent these guidelines to a court-ordered forensic evaluator who obviously had not done any of her homework before interviewing my blind client. Her questions showed absolutely no knowledge of blindness or the skills that blind people use. It appeared that her starting point was that my client could not possibly take care of his children without a sighted person present and assisting. In the current climate, the key to successfully defending against termination or supporting a parent in a custody dispute is to educate the decision makers about the parent's functional abilities. One way that we're doing this is bringing in experts who understand the nature of the disability and the accommodation and supports that that parent uses. Everyone here knows that there are thousands and thousands of blind parents in this country who are successfully taking care of their children. However, when a judge asks me what that number is, I'm unable to give an answer. I would like to work with the NFB to see if there is a way to figure this out. Judges and caseworkers keep asking this question. It might sound silly, but they want to know. And for those researchers in the audience, although we do have some excellent research findings that demonstrate that blind mothers are just as capable of meeting their infants' needs as sighted mothers, and that there are no differences in the emotional state of children raised by sighted versus blind parents. And in fact, the children of blind parents may be more adaptable and have more positive peer interactions. And that a parent's disability is not a predictor of problems or difficulties for the child. And that separating a child from a parent is traumatic and detrimental. But we still need more research to show that the biased assumptions that many people are making are just plain wrong. I look to those in the audience who are connected with researchers to figure out how we can broaden both pieces of this scholarly work to help change the culture. And on the legislative fronts, states must put in place protections for parents with disabilities in both their child welfare and child custody statutes. Legislation must include a non-discrimination statement. Court or government-ordered evaluations must be done by experienced evaluators who understand people with disabilities and the accommodations that they use. The 2012 American Psychological Association guidelines should be required to be used. And there should be training for family court professionals. And most importantly, statutes must require proof of a nexus between a parent's disability and harm to a child before any adverse action can be taken. And here's another recommendation that I would love to see in statutes. I believe it's in one current state statute now. Judges should be required to explain their reasoning and demonstrate in a written opinion the absence of bias. They must tell us why there is a nexus between the person's disability and harm to the child. Congress should take steps to protect parents with disabilities by adding specific protections into the law. And courts should give deference now to the Department of Justice's interpretation of Title II of the ADA and hold that that law applies to child welfare matters, including termination of parental rights. As the Supreme Court of California so wisely stated when it considered the rights of a parent with significant physical disabilities, the court held or stated for us, the parent-child relationship lies in the ethical, emotional, and intellectual guidance the parent gives to the child through his formative years and often beyond. It is our job to convince the court and others that it is the capabilities of the parent, not the disability itself, that are relevant. I look forward to continuing my work with you on these important and profound issues. Thank you for the wisdom you have taught me and the confidence that you have had in working with me. I'm honored to represent you.